Welcome again to the TPN Credit Bureau YouTube channel. With me today in studio is William Fullard, the Director of Fullard Mayer Morrison, the drafting attorneys of the TPN Commercial Leaseback, as well as the COVID-19 relief documents that we made available to clients free of charge from the beginning of lockdown. William, we've drafted new documents for the TPN Commercial Leaseback, very exciting. We know we're going to talk a little bit about disclaimers today and how sort of disclaimers fit into the commercial property realm. Just speak to us a little bit about what is a disclaimer precisely. How does a disclaimer work in the business?
Well, Peter, a disclaimer is a notice that an owner or occupier of premises gives to a person who's about to enter onto those premises. So another word for a disclaimer is an exemption or perhaps even an indemnity, and that gives you a fair idea of what you're trying to achieve with the disclaimer. But in simple terms, what the disclaimer notice will say is that if a person enters onto premises and suffers harm or injury whilst on those premises, the owner or the occupier of those premises won't be liable.
Okay, and you talked about somebody entering into the premises. Is the disclaimer only applicable to visitors, or is it to other people as well?
So,
or is the duty to disclaim on behalf of the landlord or the occupier of the premises, is that owed only to visitors or to other parties as well?
So Peter, the duty arises out of the common law. And what we know from the common law is that an owner or occupier of premises has a duty to ensure that people who come onto his premises aren't exposed to harm because of dangerous conditions on those premises. So a prudent landlord is going to respond to that liability in one of two ways. He's going to take out insurance. It's always the correct thing to do. But he's going to try and limit his liability contractually by means of a contractual disclaimer. Now, the duty, in fact, is owed to the public at large. So if you were to ask the average landlord, he would probably accept that he owes the duty to the tenant.
Yes.
But our courts have made it quite clear that that duty doesn't arise contractually.
Yes.
So yes, it is owed to the tenant, but equally it's owed to an invitee, to a customer, to a service provider, and somewhat controversially, even to people who might not have any business of being on those premises, such as a trespasser, for example.
You talk now a little bit about contractual indemnities, and you made mention in your article about specific ticket cases. What is the rule surrounding contractual indemnities? Is there specific set rules that you sort of have to comply with your contract if you're indemnifying yourself?
Yeah, that's a great question, Peter. So it is always important to remember that a disclaimer is a contractual instrument. And that's something that's quite difficult to get one's head around, because we tend to think of a contract as a formal written document that is signed by parties. But the truth is that, except for a few limited exceptions, most contracts aren't concluded in that way and don't need to be concluded in that way. And the classic example is what we lawyers like to refer to as ticket cases. Now, those ticket cases are actually quite important, and it's worthwhile examining a bit further, because exactly the same rules that apply to ticket cases apply to contractual disclaimers. So the classic ticket case is where you have someone who wants to book a seat on an aircraft or a berth on a ship. And typically what that person will do is, once making the booking and making payment, is that person will be issued with a ticket by the carrier. Now that ticket will have terms and conditions on the reverse.
Usually very small right at the back.
Yes, quite small. Either in full or an extract of the more important terms and conditions. Now, clearly a ticket is not something that's going to be signed by the carrier and by the passenger making the booking. Yet our courts have had no difficulty in finding that the parties have concluded a contract on the basis of those terms and conditions. And the theory is that by embarking on the ship or the plane, the passenger is taken to have accepted those terms and conditions. So if we can just run through the rules of ticket cases, there are three main rules. The first is this: if it can be shown that the person read those terms and conditions, the person is bound by those terms and conditions, even if the person doesn't understand them. The second rule is that if the person knows there are terms and conditions and deliberately chooses not to read them, the person is still bound. And the third rule, which is the most important for contractual disclaimers, and certainly for our purposes, is that even if the person hasn't read the terms and conditions, even if perhaps the person doesn't know that there are terms and conditions, the person will nevertheless be bound if the other party did what was reasonably necessary in the circumstances to draw his or her attention to those terms and conditions.
Great summation of ticket cases. Thank you so much. And then with a disclaimer notice specifically, because I know we've now talked about disclaimers and we've included these disclaimers in the TPN commercial lease pack. Are there specific rules to disclaimers placed up on a business premises, or say, for example, at a shopping center? What is those specific rules for those disclaimer notices?
So again, coming from the ticket cases, the main rule is that the owner or occupier must do what is reasonably necessary to draw the person's attention, A, to the disclaimer, and B, to the contents of that disclaimer. So what is reasonably necessary, unfortunately, depends on the circumstances. So there aren't any hard and fast rules, but we can glean some pointers from the case law. And I want to mention three things. The first of these is what we do know from the case law is that the disclaimer notice should be posted at the entrance to the premises.
Okay.
It's not good enough, for example, just to have a disclaimer notice in a cafeteria or in a public bathroom, because by that time, of course, the person has already entered the premises and may even have encountered the dangerous conditions that might exist there. The second thing we know is that quite apart from the notice being at the entrance to the premises, it needs to be prominent. So it can't be hidden in a little nook and cranny. It can't be obscured by an advertising hoarding, by a dustbin, for example. And the third point, and this has been repeated by the courts time and time again, the notice needs to be legible. So if, for example, the notice is at the entrance to a parking lot, you must be able to read it from your car.
Okay.
You mustn't be required to get out and get up really close to see the contents. And equally, if it's at the entrance to a retail center, for example, a shopping mall, you must be able to read it as you move in. You mustn't have to go up really close and take up your microscope.
I'm sure there are lots of landlords listening to this right now going, ooh, we need to go and have a look at this. What have you drafted for us for the TPN commercial leaseback, for the disclaimers?
So, Peter, we've drafted 3 disclaimers. In drafting the disclaimers, there's always a toss-up between brevity and protection. So in theory, the more you write and the more verbiage you use, the more protection you can give an owner or occupier of premises. But the problem is that if these disclaimers are going to be put on notices, as they often are, you can't have a disclaimer that is 1,000 words long. So we've tried to strike the right balance. We've done 3 disclaimers. So just to go through a bit about what's in those disclaimers. You have to think about a few things. So the one thing you have to think about is that, yes, a person may suffer injury to his person, but a person might also suffer damage to his or her property.
Of course.
So the average person entering a shopping center, for example, may have a car, will have a watch, a wallet, a cell phone certainly, and probably even a laptop. So all 3 of the disclaimers that we have drafted cover both types of injury and damage.
Fantastic.
The second thing you have to think about is that our courts have repeatedly said that you can contract out of negligence. So all of the disclaimers that we have drafted specifically say that the owner or occupier will not be liable for harm arising out of its own negligence. And we've taken that a bit further in the longer disclaimers by specifically excluding liability for gross negligence. And it's often thought that you can't exclude liability for gross negligence, but our courts in fact have said that you can. So then you get into the realm of certain things that are more harder to deal with. So one of the things you have to consider is that a person entering your premises might be a minor. And a minor, of course, might not have full contractual capacity. So in the 2 longer disclaimers, we have tried to deal with that by saying that if those minors are accompanied by their guardian, the guardian will provide the relevant contractual capacity for them to contract. And then finally, and this is unavoidable, one of the problems with the disclaimer is that it obviously can't bind people who don't encounter the notice, who perhaps don't enter the premises. So what you might find, for example, is that someone dies on your premises and you then face a claim by that person's dependent. Now, there's nothing you can do about that. The spouse perhaps has never been into your premises, certainly wasn't there at the time. But what we've done in the longer form of the disclaimer is we provided a disclaimer by the deceased. So in as much as you might face a claim by the dependent for a loss of support, for example, you will then have a corresponding claim against the deceased estate.
Fantastic, William. It sounds very complex the way you've spoken to us now. Thank you very much for simplifying everything for us. Remember, the documentation that William has discussed with us today is available for all subscribers to the TPN Commercial Lease Pack. If you're not a subscriber yet, go to the TPN shop. The link will be in the description here under. For more of the commercial property insights, please follow us on the TPN YouTube channel. Click that subscribe button as well as ringing that bell. Have a great day further.